What are the distinction between entrapment and instigation? Good day everyone. Welcome back to my channel. At kasama niyo po ang iyong lingkod, Recognizance, sa isa na namang panibagong dagdag kaalaman. For today's video, we will discuss about entrapment and instigation. In fact, nowadays, it is very common to us to hear about the circumstances involving entrapment and instigation. Most especially on cases involving violation of Republic Act 9165, or also known as the Comprehensive Dangerous Drugs Act of 2002. Now let us differentiate entrapment and operation as to the legality of the act, as to the criminal intent, and as to the applicability of absolutory causes. Now, as to the legality of the act, entrapment is defined as a lawful act or a valid act, a legitimate act of a police officer by using means and ways to arrest a person, to capture the person who are committed a crime in his presence. On the other hand, instigation is considered as an unlawful act, an illegitimate act, or an invalid act of a law enforcement officer by inducing, by persuading, or prodding a person to commit a crime and to arrest the would-be criminals. As to the criminal intent in the commission of the crime, when we talk of entrapment, the criminal intent or the criminal mind is on the offender, is on the perpetrator of the crime. While when we talk of criminal intent on cases involving instigation, is on the police officer, is on the law enforcement officer who induce a would-be criminals to commit a crime. Now, as to the applicability of absolutory causes. In entrapment, absolutory causes is not applicable. On the other hand, absolutory causes or application of an exempting circumstances on cases involving instigation is applicable. Now, let us have an example in order for you to understand of what really the difference between entrapment and instigation. Now, A is a police officer. So, he wanted to buy, or part of their planning or methods and ways in order to apprehend the perpetrator of the crime is to buy an illegal drugs against B. B is a well-known or a known person who engaged in selling and transporting of illegal drugs. Now, ipalit na si A sa illegal drugs nga gikan ni B. Pagkahuman ng palit, upon exchanging the money coming from A police officer, which is considered as a marked money, and to B, who is a well-known person who engaged in selling and transporting of illegal drugs. Police officer directly apprehended, or ang mga kauban ni police officer in the conduct of that operation is gi-apprehend si B while on that transaction. So nakuha ang illegal drugs, nakuha sa ng mark money, nakunita ng mark money ni B, and then gidakop siya sa mga police officer. Now, question. Is that act considered as an entrapment or considered as an instigation? So based on the facts that I have mentioned, such act or such fact is considered as a form of an entrapment, and it is called as a buy-bust operation. Based on the facts, there was a solicitation of evidence. There was a solicitation of evidence in order to acquire and to arrest the offender. Meaning, ma-arresto ang offender caused in the act. Gi-arrest siya while in the commission of the crime sa katong pag-exchange between the marked money and the illegal drugs. Now, there is one case that the offender questioned the act of the police officer, that according to them, the act of the police officer is considered as an inducement, and the act of soliciting evidence against B is considered as an instigation. However, that argument was resolved on the case of People versus Santa Maria, that based on the decision or ruling of the court, that the act of soliciting evidence is considered as a decoy solicitation. And that decoy solicitation is not tantamount to inducement or instigation. Therefore, B is liable for the crime he committed. Now, on the application of absolutory cause, since that example is considered as an entrapment, absolutory cause is not applicable. Why? Because the criminal mind or the criminal intent is on the person who committed the crime and not on the police officer. Claro? A buy-bust operation is considered as one form of entrapment. Ang gihimo ni police officer nga nagpalit siya og drugs is considered as a means and ways to apprehend the perpetrator of the crime. Walay inducement nga nahitabo. Klaro, sa entrapment. Now, let us have another example para atong isulod sa instigation. And let us distinguish again between the act of the police officer, whether it is an entrapment or whether or not it is an instigation. Now, going back to a police officer na si A. And now, ang atong B is considered as an ex-convict or an asset sa mga police officer. Now, niyon si police officer, B, mamalihog ko nimo og palit og 100 grams of illegal drugs. Now, in good faith, si B, to follow the order or command of a police officer, yang gisunod, nipalit siya og illegal drugs. Now, pagbalik niya nga nagdala na siya sa illegal drugs, is gidakop siya. Gi-arrest si B by the police officer who inducing him to buy that certain illegal drugs. Now, question. Is that act of the police officer considered as lawful or in the exercise of the performance of his duties? The answer is no. Why? Because the criminal intent to buy, the criminal intent sa pagpalit ang nga drugs is naa ni police officer. And in fact, dili na siya trabaho nga manugo siya sa pagpalit sa drugs because in the first place, buying an illegal drugs is a violation of the law. It is prohibited under Republic Act 9165. Now, let us apply instigation based on the definition that I have mentioned earlier. I already mentioned that instigation is an unlawful act of the police officer. It is an act by inducing a would-be criminals to commit a crime in order to effect arrest. Now, gisugo man to ni A, si B nga magpalit og illegal drugs. Atong i-determine, is an act of the police officer lawful? The answer is no. Now, let us determine about the criminal intent. As ang criminal intent, naa ba ni B nga gisugo ra siya ni police officer or naa ni police officer nga nagsugo ni B? So it is very clear based on the facts that I have mentioned nga ang criminal intent is naa ni police officer nga gisugo siya nanganing sugo siya ni B sa pagpalit og illegal drugs. Meaning to say, let us consider based on that example that B is acting on good faith. Therefore, na-inducement ka na hitabo. Ha? Since there was an inducement happened on that facts, therefore, matawag nato nga naay instigation. Since there is an instigation, and based on the definition that I have mentioned earlier, absolutory cause is applicable. Therefore, B now is exempted from criminal liability. So, unsa din na siyang gitawag nato nga absolutory cause? An absolutory cause, it is an act that is considered as a crime. However, it is not punishable by law by reason of public policy and sentiments. And in fact, if you can remember, when I discussed about felony, I mentioned the word actus non pasitrium nisi minsitria, or an act itself is not a crime unless her intention were so. Meaning to say, dili mahimo ang usa ka act nga crime unless you have the criminal intent to commit such act. So, muna siya gingon sa actus non facitrium nisi minsitria. Now, let us have another example. When A is an ordinary citizen and B, siya ra gihapon, itong gitawag nato nga, si for example, an asset or an ex-convict. Gisugo ni A si B. Again, A is an ordinary citizen. Dili na siya law enforcement officer, dili na siya police officer, dili na siya PDEA agent or NBI agent or any person who have the power and authority to impose the law. So, ordinary citizen ang nagsugo ni B. Ningon sa A, B, mamalihog ko nimo og palit og illegal drugs, mga 100 grams lang. Now, ning sugot si B. Palit siya, iyang gihatag ni A. Now, nadakpan sila sa law enforcement officer nga naay nahitabo nga pagpalit ni B og na-acquire sad in the possession of A. Now, pwede ba mo ingon si B nga, Sir, gisugo raman ko ni A. Therefore, di ko ma-held liable because I was being instigated by A or induced by A to buy an illegal drugs. Exempted ba siya? Kaniyon matag exempting siya under absolutory cause or exempting circumstances? The answer is no. Why? Because the one who instigated B is an ordinary citizen. Therefore, instigation is not applicable. Applicable lang si instigation kung ang nagsugo nimo is law enforcement officer, a PDEA agent, or an NBI agent. Now, the one who instigated you or instigated B is an ordinary citizen. Therefore, they are both principally liable. B is liable as principal by direct participation, and A is liable as principal by inducement. So, with that definition between entrapment and instigation, I hope you understand clearly about those circumstances that will define the so-called entrapment and instigation. And as a whole, when we talk of entrapment, of course, it is a lawful act exercised by a law enforcement officer by using means or method, by way of example, by a bypass operation. And when we talk of instigation, it is an unlawful act of a law enforcement officer by inducing someone or by inducing a would-be criminals to commit a crime. And as to the criminal intent is on the mind of the offended party when we talk of an entrapment. And on instigation, the criminal intent is on the mind of the law enforcement officer in order to effect arrest to a person who is innocent in the commission of the crime. Now, on the application of absolutory cause or exempting circumstances is not applicable on cases involving entrapment. While on instigation, absolutory cause or exempting circumstance is applicable when a person is being induced to commit a crime. And they also gave us a distinction between the two, that when we talk of entrapment, it is a trap to unwary criminals. While instigation, it is a trap to unwary innocent. I hope you understand the difference between the two for this very short video. And please subscribe and hit the notification bell for more updates. Thank you and God bless.